to do in the meantime, I've received a few questions on the link that we had shared with you, which is a document where an Excel sheet where you could post the question. So I will take up those questions first. But you could also, yeah, you could. You are live now. Okay, hold on. Hold on. Yeah, hold on. Let me just refresh my page. Yes, we are live now. We are live. An Excel sheet where you could post the questions. So I will take up those questions first. So we are live now. So what we will do is, I'll first give a brief introduction to the course, and which many of you are aware of, because we are into the course. We are probably in the last leg of our course. Then I would take up some of the questions that have come, which through the Excel sheet that has been shared with you. And finally, I will also look at if you have any questions that have come, in the meanwhile, or you couldn't post some questions on the Excel sheet, probably you could use the chat box here or the Excel sheet link. I have my colleagues who are looking into it. So either way, you can put it on the Zoom or on the YouTube link or in the Excel sheet or in any of these places. If you are on Zoom and if you want to speak up, you can just raise your hand and then unmute your mic and go ahead and post the question. This is all okay with us. Now, this course is a course which I've been running for quite some time, since probably 2016 or 17. And we try to offer this course every 6 months. Now, this course is titled Patent Law for Engineers and Scientists. This was designed with the key purpose of helping people understand, non-lawyers, let me put it that way, non-lawyers understand different aspects of patent law, which is a legal subject. So that's why we titled this as Patent Law for Engineers and Scientists. So non-lawyers, when they usually come across a legal subject, traditionally there is some difficulty in understanding the legal concepts. So we had designed this in a way which scientists and engineers with no background in law can understand the course easily, and they can also come up to speed on the subject of patent law. And patent law, as you all know, is a techno-legal subject. There is technology in it. A huge part of it is nothing but technology. But there are some legal principles and concepts you need to understand even before you get into the domain. For instance, inventive step does not take the literal meaning of what we understand in the English language. It is something, it has a particular legal meaning. It is defined throughout the world as something that is not obvious to a person skilled in the art. Now, that brings the concept of non-obviousness and the concept of a person skilled in the art. These are all legal concepts which have evolved over a period of time. The courts have explained them in great detail in our country and in other countries as well. Then these concepts have got the patent office. So when you file a patent application, the patent office will look for whether the invention as you have drafted and filed, or whether as you have invented it, involves an inventive step. And there are multiple criterion by which they can decide whether you have satisfied the requirements of an inventive step. So that is just the gist of how this field has evolved as an interplay between the sciences. When I say the sciences, I'm referring to science and technology, more particularly to the physical sciences as we understand it, and law itself, law as being a social science. So you can look at patent law as an interplay between the physical sciences and the social sciences. So that it does bring in some aspects of it, and you just to do this course, you just need to have a very bare understanding of how law works. But at the same time, you would also know that there is another aspect of patent law which pertains to the drafting part, for which we have another course which got over it. It's a shorter course, patent drafting for beginners. So the way in which we designed these two courses initially when we launched it was to ensure that this course, Patent Law for Engineers and Scientists, could cater to preparing for paper 1 of the patent agent exam. Now, I'm conscious of the fact that some of you may not be even interested in taking the patent agent exam. Others, and I've seen many of the past students, including some of the professors who are actively teaching in various universities have taken the patent agent exam, and they've cleared it with shining marks. I mean, they've come out very highly in the grades. So what this course does, apart from introducing you the legal part of patent law, it also prepares you to take the patent agent exam if you are interested in doing that. So that's an add-on if you ask me. So we designed the course. So if you look at there's a question that was posted, what is the way, what is the design of the exam? Now, the simplest answer would be you could just go to the Google and type for past papers of the patent agent exam in India and see the question paper. Our paper 1 is exactly going to mimic that in some sense. So the paper 1, which is wherein they look at various aspects of patent law, the Patent Act, and the patent rules, is covered in this paper. But we can cover it from the field of a concept. We detail and we explain all the concepts, and we also use the Patents Act as the ground, as the fundamental document, Patents Act and the patent rules. Because essentially, if you are an engineer or a scientist, and if you need to understand patent law, these are the foundational documents that you need to understand. So if you look at the course and the videos, we take you through various provisions of the Act and explain it in a way in which you can understand. So this has been the objective of launching this course. And I can tell you, I mean, and thanks to the continuous efforts of my colleagues in NPTEL, this program has been a success in the sense that it has given people another option in their career. Now, you could be a scientist, but still you want to pursue IP as one of the aspects in your career, and this is a great course for you to do that. If you clear the patent agent examination, even without the objective of becoming a patent agent and practicing, still within your organization, say you are working in the IP department of a big R&D company, or you are in the legal department, or you are in the R&D department, then clearing this course will put you on a completely different career track, if I can say that. Because now, apart from being good in your work, which is doing research and development in an R&D based organization, are also in tune with how your rights that come out of your R&D efforts can be protected. And it's for nothing. I mean, I know instances where people have just cleared the exam by watching the course or doing the course while they were commuting from their work to home. I mean, in some cities, especially in Bombay, it takes quite a lot of time to commute from work to home. And I know instances where people have actually cleared the course just by doing all the work that they had to do during their commute time. And for that reason, we have kept them, these videos can be watched even if you listen to the audio itself and then look at the videos or the gist of it, you can still make quite a lot of progress in these courses. So this was the objective of launching the course, and it's a testimony that NPTEL has contributed. I would imagine that NPTEL has been the biggest contributor in terms of people clearing the patent agent exam in the last few years, and given the fact that the reach of NPTEL and the fact that there are so many young people who are coming to understand this and to look at this as another career option. You could be steeped in the sciences, but still having an understanding of how the IP regime works, how the patent law works, gives you an extra advantage in moving forward in your career. So this has been a great initiative. And I would say that some of you, I mean, not all of you may be trying to take the patent agent exam, but this gives you an option for you to look at your career in a completely different dimension. Now, the course itself, as I said, is designed around Patent Act, the Patent Act of 1970, and the patent rules. That the rules have been amended constantly in the last few years, 5 years. We have seen multiple amendments to the rules, but the Act has been amended only in 2005. The last amendment was in 2005 because, as you know, the Act requires a parliament effort. You have to pass a bill for amendment. The houses, both the Rajya Sabha and the Lok Sabha, has to pass it, and only then the Act becomes the law. So even if it's a small amendment, you just want to change one provision, the process is the same. File a bill, both the houses of the parliament has to pass it. It has to get the presidential assent, and only then it becomes the law. But the rule is much easier to pass. It's something which can be done, the patent office can draft it and it can get approved. You publish it for comments, and finally, I mean, it's completely the power for passing the rule is not through a parliamentary process. So the rules are much easier to change compared to the law. That's the reason why in the last 10 years, the rules have been amended multiple times, and we have not seen a single amendment to the law since 2005. So that gives you how things are structured. But there are some limitations. You cannot amend the rule in some cases where without amending the law. If you want to change something in the law, the way to change it is by, for instance, is not happy with section 3D. And the 3D is there. It has been there since 2005 with us. Or they want to make an amendment to the 3D. There is no way you can do it by amending the rules, because rules can only explain what is there in the law, in the act. It cannot add something or derogate from what is already there in the act. So it can be only by way of explanation and addition. It cannot be by way of derogation and by increasing or adding something which is for which there is no foundation. So there are some limitations on how it can be done. So the act itself, if you see, is structured in a nice way. There are more than 150 sections, and the rules, the act, I'd mentioned this in our lessons as well. The act actually mimics the life of a patent. The life of a patent starts with application. I mean, that's the life of the patent in the patent office. Now, before that, you have the creative process. You have the various iterations the inventor has, and then probably the drafting process if the inventor gets in touch with a law firm or a patent agent to help them in the drafting. Now, all these things culminate in the application, but the life of the patent starts with application. Now, section 6 is actually who can apply. Now, from then on, you have, once you apply, it gets into the patent office. Then there is this process of publication, followed by the process of examination, where the patent office looks into it. It gives you various feedback on your draft. It gives you inputs on whether the application that you have filed is patentable, what are the objections to it, whether you have satisfied all the requirements under the act, and a whole lot of things. It's like an official action. Now, this goes on for some time, in some cases for years, and finally, a person may get a patent granted, or in the other case, it may get rejected. Once the patent is granted, then starts the time for keeping the patent alive by paying renewal fees. This goes on for another few years, 20 years. Totally, it's 20 from the date of filing the application. But if your patent gets granted in the 3rd year of your filing, then you have remaining 17 years of life. Now, this happens over a period of time. And then you finally have the patent expiring after 20 years. Now, if you look at the act and the rules, they are structured around this design. There's an application, there is a process of examination and examination within the examination and what we call prosecution within the patent office. Then there is a grant. After grant, there is exploitation. Exploitation, how you commercialize your invention, how you stop others from infringing your invention. All these things are a part of the exploitation. Now, and finally, after 20 years, it expires. So you see the act and the rules actually structured around the life of a patent, which makes it easy for us to learn. It's so easy for us to learn patent law because it is structured around this design. Now, so this is part 1 of the patent agent examination, this paper. To understand elements of drafting, then you will have to get into the other course that we completed. It was a 4-week shorter course, which is titled Patent Drafting for Beginners. So those of whom who have not taken that course, probably you can check that out. Probably in the next semester, we are offering that again. And our experience has been these 2 courses will give you a very strong foundation to not only clear the patent agent exam, but also to launch your career as a patent agent or as an IP expert, because it gives you the foundation on which you can, obviously you have to do some effort beyond that. But apart from your own effort, this is, we have found that the way in which we have designed the course and this course and patent drafting for beginners has actually been very helpful for people to crack the patent agent exam. Now, with that, it's a very short, brief introduction, and these are themes which we have already covered in the course. I would just take you through some of the questions that are there, and please feel free to use the chat here or in. I'm not, because there was an echo that was coming because I had my YouTube window open. I had to shut down the YouTube. So I'm not looking into YouTube, but I have my colleagues looking into YouTube comments. The best way for you to share your comments will be through the live session Excel sheet, which I'm looking at right now. And I'll just pick up some of the questions to and answer them to the best of my ability. abilities. If it requires a more detailed answer, I'm sure, I mean, for me to give you references to sections and rules and articles other than what is already covered, then I will have to take time to look into and give you a more detailed answer. So the first question is, IPAB still exists or has it been abolished? It has been abolished. Without doubt, it has been abolished, but you will still find the video because they were all created in one go, and IPAB is actually part of something else. But we had circulated, and we always circulate this. There is a note on the abolition of IPAB, which is a part of the study material, and in which we very clearly say that the IPAB is today abolished. Everything that the IPAB has been doing has now been shifted to the High Court. So this was the law before the creation of the IPAB. Now you may ask, the IPAB is a creation that came with the 2003 Trademarks Amendment Act. So it was of recent origin. What was the appeal procedure before the IPAB? Now, before the IPAB, every appeal from the Patent Office went to the High Court. Now we have gone back to that situation. Now some courts, there is also a Commercial Courts Act which has come in, which is largely how some high courts will have commercial courts within them, and the IP matters will go to those courts, though more like dedicated courts to look into commercial matters, because commercial matters do have a timeline. For instance, any patent matter cannot be delayed for more than 20 years because that's the life of the patent. And if you delay a patent, in deciding a dispute that comes out of a patent, you are actually eating into the life of the patent, because the life of a patent, as we all know, is 20 years. So you can look at the commercial courts as a fast track mechanism to look at IP disputes. So the IPAB has been abolished, and we had circulated a note to that effect. And what today happens is that if you file a case, it has to go straight, not to the IPAB, it has to go to the High Court, the commercial division of the High Court, or in some courts, there will be a dedicated IP court itself. Okay, so and how relevant is this for the patent agent exam? Because now that the IPAB has been removed, all the sections on IPAB has been removed from the Patents Act, there will not be a question, because this domain of litigating before the High Court is a domain where only the lawyers can do it. So it's not a domain in which a patent agent can operate any longer. A case in the High Court can only be, patent agents can obviously help them, but appearing and arguing the case is going to be done by lawyers. So there is a shuffle, I mean, in the sense that there is a shift from, because in the IPAB, the patent agents could appear and argue, but now that has been removed, and now it is only the lawyers who can appear before the High Court. Obviously, the patent agents can go and assist them. That's not an issue. They can always be a part of the team. So the change is that from the viewpoint, if you're looking at it from the viewpoint of the patent agent exam, then the patent agents are now, because the IPAB has been abolished and removed from the scheme of things, now the patent agents will not be playing a role in the disputes as traditional compared to the role that they were doing before the abolition of the IPAB. So there is a note to that effect. You can please look into the note. We will, if necessary, we can post that again in the forum so that you can have a look at that. Now, there's another question. Could it be possible to get the paperback book of the Handbook of Patent Law? 2023 edition. Now, just for the reasons I have mentioned just a while ago, that there have been multiple amendments to the rules in the last few years, and you can expect more amendments to the rules. I find it very hard for any publisher to catch up with the speed at which things have been amended and come up with a paperback book. Now, the paperback is the once you publish a paperback, and in the next few months, if there is a amendment to any rule, it is redundant, it's outdated. So you may have to pull out all the copies and print fresh copies. So I somehow find that, because I was in charge of Lex Campus, I mean, right now we don't have any operations, but while it was running, I was in charge of it. I found that it is much easier to have a online version of an act and the rules, because the handbook contains the acts and the rules, than having the paperback edition, because it's much easier, because you can be amenable to all the amendments that happen. You can incorporate them in real time, and it is more environment friendly. Just imagine printing 1,000 books and then pulling that all off, and then again coming up with another 1,000 book because they just changed a few sections or rules in the act. I mean, it's a crime in today's world to be doing that kind of stuff. There's not sufficient demand for this. If it were there, we could have explored print on demand. I mean, that could take care of this need for a paperback. Print on demand is you have an arrangement with the publisher and have the most updated online copy with them. And anybody who needs a copy just goes to that place and they get a print on demand copy. That's going to be a slightly more expensive option. But I think today we all should get used to using e-copies and becoming more efficient in using e-copies. Okay. Now, another question is on the exam pattern. I've already mentioned that in some detail, that the examination is completely, the exam mimics the paper 1 of the patent agent exam. Largely, it is going to be, this exam is going to contain MCQs. That's it. We don't have an essay type question in this exam. And we have different types of MCQs, in the sense that we have MCQs wherein only one answer is correct. We have MCQs wherein multiple answers are correct, and we have a true or false section. I mean, that's it. I mean, this is largely and if you want to know, you can chat with us on the forum, and we'll be more than happy to share some of the old question papers, or you can find them on the internet itself. I mean, if you look for a patent agent exam, I mean, that is the IP patent agent exam, you will find paper 1. It's largely the same pattern. Now, those are the questions that I could see. Are there any other questions? People in Zoom, if you want to unmute your mic and ask some question, please go ahead.
Hello, sir. Am I audible?
Yes, Pranav, I can hear you.
Hi. Hello. So, first of all, thank you so much for the course. It was very nice, and I learned a lot. I just wanted to ask, I have given the patent agent exam in 2022, but unfortunately, I could not make it in the paper 2, the drafting.
Paper two, yeah.
I passed barely, like 48 marks I got.
Okay.
So
in paper 2, right?
In paper 2, yes. Paper 1 I cleared.
Okay, excellent. Okay.
Yeah.
This was before the course, or this was before you took this course, right?
Yes. In last year.
Okay, last year, 22. Yeah.
So it would be really great if you could just give some pointers on drafting paper for patent.
Okay, Pranav. Normally, I'm very strict with my time, but anyway, we have very few people here, and more importantly, this does not pertain to this paper. I mean, Pranav has asked a question, but I'll answer that. Pranav has asked a question that paper two is what, which is a twin course of this. It is a twin of this course, but paper 2 we have already finished it. So Pranav wants to know that Pranav has already taken this exam, patent agent exam, and unfortunately, Pranav missed it by 2 marks. If Pranav had got 50 marks, he would have cleared it. Am I right, Pranav?
Absolutely, so correct.
Yeah, he just missed it by, that's really hard luck. It's unfortunate, but Pranav wants to know how he can prepare well for the patent agent exam, the next one whenever it happens, and ensure that he clears patent drafting with flying colors. Okay. Now one of the Pranav, one more question for you before you have you taken the patent drafting beginners course, the short course? Have you taken that?
Yes, sir. Yes.
Okay, excellent. So you are in a much different position than you were before.
Correct,
so what I would suggest, Pranav, is like drafting, and if you see that it's a shorter course for a very important reason. This course runs into 12 weeks, that course runs into only 4 weeks. We only touch upon the basic principles of drafting. That's it. And our objective is very clear. And one of the things I reiterate to people who are clearing the exam is that you have to get into a habit. And this is personally completely left to you, because this is not something which we can teach on a day-to-day basis. You have to get into a habit of reading very good, high quality patents, reading them. That's every week, and making some notes about it. Now, what does this do? Now, you have the background of everything that you need to know about patent law. You know what inventive step is, you know what prior art is, you know all the concepts, enablement, the structure of the patent, and even you have some idea about drafting, the problem solution approach that we have, all the patterns, the well drafted patterns will actually the background of the art, which will end with which will identify a problem, and then the summary of the invention will actually be pitched as a solution to the problem. This is a technique. I mean, it's a very, very well-known technique of drafting. Now, when I say that you have to read, I mean, depending on your motivation, you have to read at least 2 or 3 patents per week. And you have to continue to do it till you take the exam. Now, what does this do? When I said you have to read well-drafted patents, I'm talking about the patents that are drafted by the leading companies today. What is your area in which you are working, Pranav? Which is the domain? You have domain knowledge in which area? Mechanical. Excellent. So mechanical. Let us expand that to mechanical and automotives. Or is there any specific thing on a mechanical, like robotics or anything that you?
Automotive filters.
Excellent. So what Pranav should do? Pranav should look at the leaders in automotive patenting, and it's very, very easy to know who these leaders are. You have Toyota, you have Honda, you have Volkswagen, you have all the leading. I mean, you have 10 or 15 leading automotive companies. Now, Pranav has to go to google.com/patents or any of the free patent databases. And when I say free patent databases, I don't want you to search into US Patent Office or the EPO. That's painful. There are patent sites which bring together all the patents acts in the world, patent applications in the world, like google.com/patents is one, freepatents.com, free patents online, I think. Okay, there are many. So you would go there and you will see what in your field, now that there is a particular field, and one of the things do is find out the IPC classification of his domain. You will be able to find that. If you go to the WIPO website on IPC, you will be able to find where automotive filters or automotive whatever exhaust technology, whatever that is, you will find those things. And now with that code, you can start searching for patent applications that are coming from the leaders, and you will start reading them. Because you have domain knowledge, you're going to love this process. You're going to enjoy this because it's in your domain and you understand the pattern aspects of it. You also understand the technology aspects of it. When you start reading them, there will be, in some domains, there'll be very few. Let us assume that there'll be just 5 or 10 patents in a month or in 6 months. So, but still, you can go back, now that you know how to search for these patents, you can go back and start reading them. Because they are the leaders in the field. Toyota obviously is a leader in the field. The General Motors, Volkswagen, Mercedes, BMW, they're all leaders in the field. Because they are leaders in the field, find a really high quality patents being filed by them. Very high quality, because either they have in-house drafting teams which are trained in some of them are scientists who are actually doing the work, and they are also helping them in the drafting. You will find really high quality patents, and many of them are competing in the field. Now, if you look at some of the technologies that have come from from the internal combustion engine, you will find that there are equivalent technologies in other companies as well. So you will find really high quality patents, and when these patents get granted, they will also look very similar to their competitors' patent. So you can say if you are looking at a dual clutch gear technology, for instance. A dual clutch is there. Volkswagen has its own technology. BMW has its technology. Then you have dual clutch in Mercedes as well, Triptonic, whatever they call it. Now, if you read these patents, you will find that there is common technology, but there are specific advantages they have claimed. Now, reading this will allow you to come up to speed, not only with the technology, but also with the latest developments in drafting that you have to do. Now you understand this domain. So ideally, if you're preparing for a patent agent exam, and the drafting part is apart from doing the course, which is just a 4-week course, and some of the videos are available freely on YouTube as well, you will now start first reading the patents in your field, which is, as I told you, you find the IPC code for your domain and start searching for patents, start reading them. Now, reading them, ideally, you should do at least 2 to 5 applications in a week. You should do that. While reading them, you will, when you get in a few weeks, you will come up to speed on some of the language part of it. You will start enjoying it. Okay, this is how you describe a claim or the main claim, and you will see the relationship between the main and the dependent claims. You will start enjoying all these things because it's in your domain. Now, after a few weeks, you will now start doing certain exercises on your own. For instance, take an application or ask your friend or some relative to mask the claims. Okay, they take the PDF, they just remove the claims from the PDF or mask it up, then give it to you and say, read and draft the claims. Now, this is an exercise you can easily do. Or you ask your friend or your colleague or your relative to cover the title of the claim. Okay, first you will have to tell them how to look for this, because you know how to search for it, and you tell them how to search for new patents. Cover the title of the claim and give it to you so that you can now draft the title of the claim after reading the specification. Or cover the abstract and read the specification and you write an abstract, because you know how to do this. So you're going to do two things. One, you're going to read the best applications in the field by the top patent filers in your field, which is in an automotive, it is all known. And you are also going some exercises of drafting. And I gave you a simple exercise. They give a patent which you want to read before you read it, give it to your colleague and ask them to remove the claims from it. You read it and draft your own claims. After you draft it, compare it and see where you went wrong or how. So this will put you on a fast track in learning, and there is no better way to do this. And if you are working in any of the top companies, this is what you will be, or if they have a patent department, IP department, this is how they will be training you. They'll be asking you to read the best material that is there and then put you onto efforts or exercises where you can do this. So this is a gist of it, Pranav, and I think it will really set you in a completely different track. You're going to be reading stuff that is interesting to you. You're going to be learning from the masters. All these companies, they are not only masters of technology, they are also masters in patent drafting. You should just read some of the there are some techniques that Honda has used. Honda, I'll just give you a very small instance. Honda sometimes writes these 100-page patent applications, very, very, very detailed, explains everything about the technology, but then they go and claim a very small portion of the invention. Sometimes they claim, I mean, I've seen a patent where they describe the internal combustion engine using spark plugs of a motorcycle, 100 pages, very detailed, every aspect of it, swirl induction and whatnot, everything in great detail. But at the end, they go and claim the nylon cover for a spark plug. Okay, you will say, what are they trying to do? They've explained the technology in such great detail, but they are only claiming the nylon push fit cover. You know the motorcycles have a push fit cover, which is actually made of nylon or some a non-combustible material, which you can push it and you can actually over the spark plug. So that when you want to remove the spark plug, you pull this cover out. It's actually a nylon push fit cover. Now they claim this. When I spoke to the industry expert, they said that this is the Japanese way of disclosing the prior art so that others will not claim it and stop them from doing something. Okay, that's a brilliant strategy if you come to think about it. But you will know all these things only when you get into it. I was involved in the Bajaj TVS, the twin spark plug case, and that's how I got to know about this. I was involved as a lawyer. So, but these are the things that you will learn for yourself. So my advice would be to look at the best applications in your field as they are coming, and the ones that just went in the last few years, read them, and then get into a habit of masking some portions of it and writing it. Okay, somebody can just show you a diagram with just some numbers, and you try to expand that in description. How will you, looking at this diagram, how will you explain the diagram in a written form? That's one of the things that gets into the thing. So what your entire effort, Pranav, will be to look at different parts of the patents, read them, read the works of the masters. I will call them works of the masters because they are the best that is available today. And then try to do some exercises by masking some portions and writing it. And after you write it, the feedback is the most important thing. You can either ask a colleague to correct it, or you can do a self-correction. Both are good enough. Yeah. So this is what I would advise.
Thank you so much, sir.
Welcome, Pranav. Any other questions? Okay, so what I will do, I mean, because we are, I'll just check whether there are any questions posted on the. Yeah, I don't see any new questions on the Excel sheet either. So we are close to our time, but what we can do, obviously, whatever has gone for will be available as a recording on YouTube. Please feel free to watch it anytime. And our communication goes beyond this. Though it's an online course, it's a remote course. You have the forum, and please use the forums. My colleagues are constantly watching the forum. If you post some question, it will be answered, and we will, if you are in need of any extra information, please let us know. We are more than happy to help you. Sometimes, like the question that Pranav just asked, it could be beyond the thing, but we are more than happy to help you on that. So, but then we would want to do it in such a way that, you know, there is some record and others can see it. So the best way to do that is post the question in the forum. We will answer that in the forum with any additional information that you would need. So that is signing off from here. If there are no further questions or clarifications that you need, all the very best for the examination that is coming, and probably for the patent agent examination whenever it is going to be hosted next. And I'm quite happy, and I'm sure that you will clear this, because as we have seen it from, it could be hundreds and hundreds of people who have taken this course, have benefited from this course, and have cleared the patent agent exam. So I don't see any problem here. But as I just explained to Pranav, there has to be a personal effort from you. And if you are a person in the industry, as Pranav just told, is into automotive filters, there is enough and more of stuff that you can learn from the masters. We have to learn from the masters. There's no other way we are going to. You can't just attend a 4-week course on patent drafting and become, come on. We know that the world is much more complicated and complex than that. So we have to put that effort in, and all the best to all of you. If there is anything that you want to know, please be in touch with us on the forum. We are watching it constantly, and we'll be more than happy to help you with whatever information or clarification that you need. So we will end this session now. So if I've just waited for questions, so we will end it now. Thank you for joining us.